Hello, and welcome back to Claims and Sustains, a Cybarth Government Contracts podcast. I'm Amy Hoang, and I'm very happy to be joined today by Christy Kiely, an OFCCP and People Analytics lawyer, here at Cybarth for today's topic, which is compliance considerations for government contractors with DEI under review. So a very timely topic. And Christy, why don't you start us off by giving us kind of an overview of the current legal landscape?
Sure, absolutely, and thanks for having me. This is a great topic to be talking about today. So I think it helps to kind of level set and talk about the big picture to start. We've been living and breathing the executive orders on DEI for about 8 months now, so you're probably a little familiar with this, but it all started with Executive Order 14173, which is what we call a Day 2 order because it was issued on the second day of President Trump's term on January 21st of 25. And that order really did a couple of very noteworthy things. The first, which impacts this community, the federal contractor community, is it rescinded Executive Order 11246, which actually was celebrating its 60th anniversary this year, so 60 years of precedent. And that is the order that required affirmative action for women and minorities. President Johnson signed it in 1965 at the height of the civil rights movement. That was revoked by President Trump. So affirmative action for women and minorities under that regime has completely stopped. Contractors were given a 90-day period in which to stop all that activity. And the enforcement agency under the Department of Labor, the OFCCP, which most of you know, right? The Office of Federal Contract Compliance Programs, they were also directed that they were not allowed to enforce this type of affirmative action going forward anymore. So that was one very big thing that the order did. The order also touched on DEI, which is what I have been living and breathing every day since January 21st. And the order really calls out and talks about wanting to eliminate illegal DEI. And I'm using air quotes not at all sarcastically, but because it's not a defined term in the order. And so a big challenge has been for contractors and really for all employers to figure out what type of illegal DEI the government is ferreting out through this executive order. The purpose of the executive order, it's got a long name, but I should give you that too. It's called Ending Illegal Discrimination and Restoring Merit-Based Opportunity. So the order is all about rolling back what was seen as excessive DEI or DEI that went too far and extended preferences for women and minorities, and making it very clear that under this administration, that type of conduct was not going to work. So that was what began it all, right? Then we got some issuance of guidance from the enforcement agencies. There were a few that came out, but one of the most noteworthy was this joint guidance that was issued by the Department of Justice and the EEOC together. And in that memo, they gave contractors some clarity about the types of activity that is going to be considered this illegal DEI, which the executive order now bans. And it's things like granting benefits or opportunities to some races or one gender and not others. Anything that is exclusionary based on traits like gender and race are going to be problematic.
So a pretty significant shift here.
Big change, yeah.
So I'm going to talk a little bit now about what hasn't changed and what is still in effect, because it might sound a little crazy, but it is definitely possible to be over complying in this environment if you are a federal contractor, because even though we've had all of these rollbacks, it's important for federal contractors to remember that you do still have certain supplier priorities that are statutorily required and still very much in your contracts. These usually show up in the context of FAR 52219-8 and FAR 52219-9. And under those clauses, a contractor is obligated to promote the government's policy of extending certain contracting opportunities to small businesses and various categories of small businesses to the maximum extent practicable. That's the -8 clause. The -9 clause takes it a step farther and says that for certain types of contractors, you actually have to have an established plan that has specific goals for how you're going to afford subcontracting opportunities to these types of contractors. So that's small businesses, small disadvantaged businesses, service disabled veteran owned and veteran owned small businesses, woman owned small businesses, historically underutilized business zone businesses. And for these categories of businesses, it is not permissible to simply throw those priorities away just because we've had these rollbacks with the administration. So as important as it is for companies to be aware of this illegal DEI prohibition, it's equally important to understand what is still in place and what is still very much enforceable as part of your contracts.
Absolutely. And you and I have worked together advising clients on this interplay before, because you're right, there is a little bit of a tension there. On the one hand, employers are being sent the message very strongly, stop categorizing employees by race or gender or making any type of decision that way. And yet within other aspects of federal law and federal regulations, there are requirements to consider things like women-owned, minority-owned businesses. But as you indicated, Amy, those are very specific, defined terms in a very specific context.
Yeah, absolutely. I think one way that we've seen some companies get tripped up is just by having an overly expansive list of the types of businesses they're prioritizing. Because for instance, while the federal government still has, a statutory requirement for contractors to be giving priorities to women-owned small businesses, for instance, if your policy says you're giving a preference to just women-owned businesses generally, well, that's a broader category than these, like you said, Christy, very narrow categories of businesses that the government is still requiring contractors to give subcontracting priorities to.
Absolutely. Yeah. And just building off of that, one thing I didn't mention at the beginning, so I mentioned how affirmative action for women and minorities was essentially eliminated with the revocation of a prior executive order. There is still affirmative action for veterans and individuals with disabilities, because those arise under federal statute and cannot be changed by the executive order. So again, you have these sort of conflicting directions in different parts of the federal government where employers need to stop affirmative action for women and minorities, continue certain subcontracting programs for minority and women-owned small businesses, and continue affirmative action for disabled individuals and veterans. So it's all very complicated, and nowhere does that come to head probably more than in the context of supplier diversity. So let's go ahead and wrap up with supplier diversity, which combines our two worlds, sort of the small business contracting obligations and then the DEI, diversity, equity, and inclusion component. So employers need to look really carefully at their supplier diversity programs to the extent they have diversity categories that, as Amy said, go beyond those defined by federal law. Because there is another law called Section 1981 under the Civil Rights Act that makes it unlawful to discriminate in any form of contracting based on race. And there are also a lot of state laws that have prohibitions about discrimination in contracting for gender and other traits as well. And so if employers are making decisions about who gets to do business with them, who will be their supplier, based on the racial or gender ownership of those businesses, there's a potential 1981 problem. So what employers can do instead is just engage in really robust outreach to small businesses, to diverse businesses, make sure they're aware of contracting opportunities, encourage them to apply, and then pick the best supplier that's going to do the job.
Right. Well, we certainly couldn't capture, I think, the full universe of all of the changes that have been going on over the past couple of months. But Christy, thank you so much for joining us and sharing your insights. And that's it for this episode of Claims and Sustains.